Yeah. So coming back to the topic, I feel this whole act, the whole policies, the whole guidelines have brought in a lot of awareness in people. The any unwelcome acts or unwelcome behavior in the workplace constitutes a thing called as sexual harassment. Also, this whole awareness came much later, much after this act came into picture, these policies came into picture, and it gave employees a confidence that if any sort of a disharmony or a discomfort is happening at your workplace, yes, you do have a redressal right. Yes, you do have a means to be able to redress it. You have somewhere to go to, and you have a whole mechanism to approach the situation. So, this is what for me is this whole evolution of sexual harassment. Now, I'm going to share with you a PPT. So, we're going to discuss as per. So yeah, like we discussed, sexual harassment in general, what it means, and how we have carved out this niche of having sexual harassment at workplace in India. Now, how did this exactly? When did this awareness come? So there was a judgment, or probably I'll tell it to you like a little story. So there was a case which happened in the year 1992. It is one of the landmark cases which happened in India called as Vishakha. It's the Vishakha judgment. And this judgment brought in that whole awareness and the guidelines which we needed for this topic of sexual harassment at workplace in India. So in this case, one such instance of sexual harassment had happened with a woman, and the Honorable Supreme Court had laid down guidelines. And because the act came much later, of course, but those guidelines set a precedential value till the act came into picture. So those guidelines were required to be followed until that whole POSH Act, the Prevention of Sexual Harassment Act, came into picture. So moving on to the Act, the Prevention of Sexual Harassment of Workplace at 2013. So we'll first discuss some major definitions under the Act. Aggrieved woman. As per the POSH Act, an aggrieved woman in relation to a workplace is a woman of any age, whether employed or not, who alleges to have been subjected to an act of sexual harassment. Employee means a person employed at a workplace for any work on regular, temporary, ad hoc, or daily wage basis, either directly or through an agent, including a contractor, with or without the knowledge of the principal employer, whether for remuneration or not, or working on a voluntary basis or otherwise, whether the terms of employment are express or implied and includes a co-worker, a contract worker, probationer, trainee, apprentice, or called by any other such name. So, like you can see, the definition of employee is so vast that it includes every kind of an employee, whether it's a contractual basis, whether it's on voluntary basis. It doesn't really have to be a regular working employee. It can be any form of employee, voluntary basis, any form of employee working in an organization is covered under this act. So we can gauge that the intent of the act is to provide protection to any and every kind of employee in the organization. Now, employer, as important as it is to know what an employee is, it's equally important to know what an employer is. So, employer here means in relation to any department, organization, undertaking, establishment, enterprise, institution, office, branch, or unit of the appropriate government or the local authority, the head of that department, organization, undertaking, establishment, enterprise, institution, office, branch, or unit, or such other officer as the appropriate government or the local authority, as the case may be, may, by an order, specify in his behalf, in any workplace not covered under subclause 1, any person responsible for the management, supervision, and control of the workplace. So basically, again, we can know that if the employee definition is so vast, the Act wants to cover every kind of employee, so is the employer. So basically, no employer can get rid of the fact by saying that no, I do not. I will take questions towards the end of the webinar, and I will throw the floor open for any kind of questions. So I request you guys to please ask whatever questions you have towards the end. Thank you. So as vast as the employee definition is, so is the employer definition. Now, sexual harassment. Now, we need to know the whole topic. We need to know what exactly is sexual harassment under the Act. So, sexual harassment includes any one or more of the following unwelcome acts or behavior, whether directly or by implication, namely physical contact and advances, or a demand or request for sexual favors, or making sexually colored remarks, or showing pornography, or any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. That is what is the definition of sexual harassment. All basically for being qualified to be able to address any instance of sexual harassment, that particular instance has to follow within these five like these five things regarding sexual harassment. Then we have the definition of workplace. Workplace is also as important as it includes basically every organization, as like I mentioned, as vast the definition, so is a workplace. Because this act intends to cover everything. This act does not want to spare out any, so nobody can basically fizzle out by saying that no, I don't qualify to be an employee, or probably I don't qualify to be an employer, or probably this sexual harassment incident has not happened in the workplace. So if these going by these definitions, if basically this act doesn't want to give anyone that whole chance to try and fizzle out of the situation. So one of the most pertinent things here is that while the Vishaka guidelines that we discussed, that in the judgment certain guidelines were laid down, while the Vishaka guidelines were confined to the traditional office setup, recognizing the fact that sexual harassment may not necessarily be limited to the primary place of employment, the POSH Act has introduced this concept of extended workplace. So like I just described, this extended workplace includes any and every kind of workplace, which has any kind of instance of sexual harassment. So this is the definition of workplace, which practically covers everything that a workplace should be like. Basically, it includes any department, organization, undertaking, establishment, enterprise, institution, office, branch, or unit which is established, financed by funds provided directly or indirectly by the appropriate government or the local authority, or a government company or a corporation or a cooperative society, any private sector organization or a private venture, undertaking, enterprise, institution, establishment, society, trust, NGO, unit of service provider. So yeah. Prevention of sexual harassment. So like we're discussing under the Act, prevention of sexual harassment is what exactly we are talking about here. The Act mentions that no woman shall be subjected to sexual harassment at any workplace. So therefore, the definition of workplace was important because workplace covers everything. So does this whole clause of prevention of sexual harassment. No woman shall be subjected to sexual harassment at any workplace. The following circumstances, amongst other circumstances, if it occurs or is present in relation to or connected with any act or behavior of sexual harassment, may amount to sexual harassment. Which is, so these basically this mentions certain acts which also may amount to, sexual harassment or incorrect behavior and unwelcome behavior. For instance, implied or explicit promise of preferential treatment in her employment. or implied or explicit threat of detrimental treatment in her employment, or implied or explicit threat about her present or future employment status, or interference with her work, or creating an intimidating or offensive or hostile working environment for her, or humiliating treatment likely to affect her health or safety. So here I would also like to mention something that these acts, if it was not for this whole POSH Act, if it was not for this whole, if it was not for this POSH Act, if it was not for the guidelines, probably we would have considered these acts to amount to something so big as sexual harassment at workplace. Because this whole thing has been given a term now, because this has been given an act, we do recognize that these acts are not everyday acts and they are supposed to be considered as sexual harassment at workplace. All of these acts, probably if this whole POSH Act was not there, it would have gone unreported. This whole idea of having this act is to spread that kind of an awareness that you don't have to worry, you can take the action now. So these acts fall under the Sexual Harassment Act workplace, and this is very much a reason to report if it is happening with any employee in the organization. So the next thing is complaints committee under the POSH Act. So like we've discussed, the prevention of sexual harassment, the ways what constitutes to acts of sexual harassment, now comes the important and one of the most significant parts of the act, which is the complaints committee. The act contains committees. So the redressal mechanism for sexual harassment at workplace in India is these committees. There are two kinds of committees which are formed under the Sexual Harassment Act, which is the Internal Complaints Committee under Section 4 of the POSH Act and the Local Committee under Section 6 of the POSH Act. So Internal Complaints Committee, every employer of a workplace shall by an order in writing constitute a committee to be known as the Internal Complaints Committee. Any establishment employing 10 or more employees is required to constitute an ICC by an order in writing by the employer. However, this numerical threshold has not been explicitly, so basically this number of employing 10 or more employees, this is a number which is mentioned in section 4, but it's not mentioned in section 4, but it's mentioned where we talk about local committees. So local, we have to gauge this exactly. We have to just interpret it from the act, because the act says that local committees at the local level of the state are formed for redressal of sexual harassment at workplace where the organization contains less than 10 employees. And in that case, the ICC is not formed. That's mentioned where we talk about local committees under the act. So basically, when we talk about ICC, it directly doesn't say that the ICC has to be formed for, in those organizations employing 10 or more employees. It's basically when the local committees say that we are being employed because an organization having less than 10 people don't have an ICC. So that's how we interpret that an ICC is supposed to be mandatory for organizations where the number of working employees are 10 or more. Composition of the ICC. The Internal Complaint Committee shall consist of the following members to be nominated by the employer, namely, a presiding officer who shall be a woman employed at a senior level at workplace from amongst the employees, provided that in case a senior level woman employee is not available, the presiding officer shall be nominated from other offices or administrative units of the workplace referred to in subsection 1. Provided further that in case the other offices or administrative units of the workplace do not have a senior level woman employee, the presiding officer shall be nominated from any other workplace of the same employer or other department or organization. Not less than 2 members from amongst employees preferably committed to the cause of women or who have had experience in social work or have legal knowledge. 1 member from amongst non-governmental organizations or associations committed to the cause of women or a person familiar with the issues relating to sexual harassment, provided that at least 1/2 of the total members so nominated shall be women. Local committee. So this was the second kind of committee which was formed under the Act. Every district officer, sorry, every district officer shall constitute in the district concerned a committee to be known as the local committee to receive complaints of sexual harassment from establishments where the internal committee has not been constituted due to having less than 10 workers, or if the complaint is against the employer himself. So here we can clearly know that if an organization, like I mentioned earlier, has less than 10 employees, then a local committee is formed, and that's the redressal mechanism if the ICC is not, in case the employees are less than 10. The district officer shall designate one nodal officer in every block, taluk, and tehsil in rural or tribal area and ward or municipality in the urban area to receive complaints and forward the same to the concerned local committee within a period of 7 days. The jurisdiction of the local committee shall extend to the areas of districts where it is constituted. Complaints under the POSH Act 2013. So the Act mentions any aggrieved woman may make in writing a complaint of sexual harassment at workplace to the internal committee if so constituted, or the local committee in case it's not constituted, in case ICC is not constituted, within a period of 3 months from the date of incident, and in case of a series of incidents, within a period of 3 months from the date of the last incident. Provided that where such complaint cannot be made in writing, the presiding officer or any member of the ICC or any member of the local committee, as the case may be, shall render all reasonable assistance to the woman for making the complaint in writing. Provided further that the internal committee, or as the case may be, the local committee may, for the reasons to be recorded in writing, extend the time limit not exceeding 3 months if it's satisfied that the circumstances were such which prevented the woman from filing a complaint within a set period. So over here, I would like to say that complaint of a section, the Act is to be able to use it. So like they all say, a tool is useless if a man can't use it. We have the Act, but probably we need to take the action, and with an Act which so clearly and with such a detailed elaboration of each and every clause describes how we can take that first step. Because probably it is a phenomenon that, if such an instance happens with any employee, probably some of the thoughts may be that, what will happen? Who do I go to? Who do I talk to? Who do I tell this to? And do I even report this? This may cause some kind of a disharmony in my workplace. This may cause some kind of this may cause some kind of a discomfort in the workplace. Probably, what will people think about me? What will the work environment be like? Will I have to leave my job? Will I get another job? These are some of the common thoughts which come to the minds of an employee when they're facing this, but they don't report it because they fear some of these reasons. But this Act clearly gives you it gives you the medium, it gives you all the ways to be able to address some discomfort which is happening with you in the workplace. Because now, specifically now after we have this Act, these acts or any welcoming behavior is not an everyday or a small thing. It may be, and it has to and it should be reported, because that's what the idea of this whole Act is. And of course, it's imperative to create it's imperative to create a harmony at workplace, because with such acts happening, even if someone doesn't report it, it's very difficult to work like this. So this complaint mechanism should definitely be put in place. You can, any employee who goes through this can approach the ICC, and they have to make a written complaint. And also, this Act states that where the aggrieved woman is unable to make a complaint on account of her physical or mental incapacity or death or otherwise, the legal heir also has the right to make a complaint under this section. Action during pendency of inquiry. So once your complaint has been sent to the ICC, the process of inquiry starts. But what happens between when the complaint is made and the inquiry is going on? So during the pendency of an inquiry on a written request made by the aggrieved woman, the internal committee or the local committee, as the case may be, may recommend to the employer to transfer the aggrieved woman or the respondent to any other workplace, or grant leave to the aggrieved woman for up to a period of 3 months. This leave shall be in addition to the leave that she would otherwise be entitled to, or grant such other relief to the aggrieved woman as may be prescribed. Conciliation. So this act has a mechanism of conciliation. The internal committee, or as the case may be, the local committee may, before initiating an inquiry and at the request of the aggrieved woman, shall take steps to settle the matter between her and respondent through conciliation. So the first mechanism that the act suggests is to have a conciliation between the aggrieved woman and the party responsible for causing the particular act, provided that no monetary settlement shall be made as a basis of conciliation. Where a settlement has been arrived at under subsection 1, the internal committee or the local committee, as the case may be, shall record the settlement so arrived and forward the same to the employer or the district officer to take action as specified in the recommendation. The internal committee or the local committee, as the case may be, shall provide the copies of the settlement as recorded under subsection 2 to the aggrieved woman and the respondent. Where a settlement is arrived at under subsection 1, no further inquiry shall be conducted by the internal committee or the local committee, as the case may be. So the Act also has a mechanism of appeal. Appeal is basically, of course, like most of you must be aware, that when a judgment is passed or when any appeal in general, it means that when something has happened and probably you stand by the fact that this has not happened and I want to appeal against it. So this Act also has that mechanism. That appeal can be made to the court or tribunal in accordance with the provisions of the service rules applicable to the said person, or when no such service rules exist, then without prejudice to provisions contained in any other law for the time being enforced, the person aggrieved may prefer an appeal in such manner as may be prescribed. If the allegations prove to be wrong, so this Act also provides for a mechanism where if the allegations that have been posed in the sexual harassment complaint, if those allegations are proved to be wrong, if the false complaint made or any forged documents being produced, the committee may recommend to take action as per the service rules or as otherwise prescribed. But if the complainant is unable to provide adequate proof, then no action is to be taken. The malicious intent shall be established after an inquiry in accordance has been made with the prescribed procedure. Committee arrives at a conclusion that during inquiry false evidence has been produced, then it may recommend action against the witness as per service rules or as prescribed. Determining the sums of money which is to be paid. So basically, when the sum of money is to be paid for the Sexual Harassment Act, apart from that, the mental trauma, the pain, suffering, the emotional distress which is caused to the aggrieved. So this whole amount of the money which is to be paid is seen on the basis of the mental trauma, the pain, suffering, the emotional distress caused to the aggrieved, the loss in the career opportunity, medical expenses incurred post the incident, income and financial status of the respondent, feasibility of such payment in installment or in lump sum. Duties of the employer. So this Act also suggests and also poses an obligation on employers to maintain a certain environment in their organization when it comes to sexual harassment at workplace, and how can these acts be prevented? Like how can they be stopped actually entirely? So every employer shall provide a safe working environment at the workplace, which shall include safety from persons coming into contact at the workplace. Display at any conspicuous place in the workplace the penal consequences of sexual harassment and the other constituting the internal committee under subsection 1 of section 4. Organize workshops and awareness programs at regular intervals for sensitizing the employees with the provisions of the Act and orientation programs for the members of the internal committee in the manner as may be prescribed. Provide necessary facilities to the internal committee or the local committee as the case may be for dealing with the complaint and conducting an inquiry. Assist in securing the attendance of the respondent, and witnesses before the internal committee or the local committee, as the case may be. So these are some of the regulations, these are some of the guidelines which employers have a responsibility, have a duty to follow. They should make available such information to the internal committee or the local committee, as the case may be, as it may require having regard to the complaint made under subsection 1 of section 9. Provide assistance to women if she so chooses to file a complaint in relation to the offence under the IPC or any other law for the time being. Cause to initiate an action against perpetrator, or if the aggrieved woman so desires, where the perpetrator is not an employee in the workplace at which the incidents of workplace of sexual harassment took place, treat sexual harassment under the service rules and initiate action for such misconduct. Monitor the timely submission of reports by the internal committee. So,
sorry if I may interrupt and ask a question here. Hi.
I'm going to have a Q&A round towards the end, if that's okay.
Okay, all right. Sorry. Yeah.
Yeah. Ways to make your employees aware of POSH at workplace. So employees can be made aware of POSH by organizing workshops, by organizing awareness programs at regular intervals for sensitizing employees on the issues and implications of workplace sexual harassment, organizing orientation programs for members of the IC. So basically, these are certain ways with which the employees can make their employees aware of the sexual harassment, because even though we have an act, but the awareness is still yet to come. So these are some of the initiatives and actions that the employers can take to make their employees aware of sexual harassment at workplace. Certain acts, like an example for sexual harassment, can be unwanted sexual advances or propositions, pestering for dates or receiving unwelcome sexual suggestions or invitations, offering employment benefits in exchange for sexual favors, luring, making sexual gestures, displaying sexually suggestive objects or pictures, cartoons, calendars, or posters, making or using derogatory comments about a person's body or dress, slurs, or sexually suggestive jokes, written communication of a sexual nature distributing hard copy or via a computer network, suggestive or obscene letters, notes or invitations, physical conduct such as unwanted touching, assault, impeding or blocking movements, being forcibly kissed or hugged, having someone expose their private parts to you, or repeatedly staring at a woman's body parts that make her uncomfortable. These are some of the examples or acts which may amount to sexual harassment at the workplace. Making or threatening retaliation after a negative response to sexual advances, or for reporting or threatening to report sexual harassment, teasing, sexually tinted remarks, whistling, staring, sexually slanted or obscene jokes, jokes causing or likely to cause awkwardness or embarrassment, subtle innuendos or open taunting regarding perfection, imperfection, or characteristics of physical appearance of a person's body or shape, gender-based insults and/or sexist remarks, displaying pornographic or other sexually offensive or derogatory material, possibly invitations for dates, possible physical touch or physical assault or molestation, suggesting or implying that failure to accept a request for a date or sexual favors would adversely affect the individual in respect to performance of evaluation or promotion. Explicitly or implicitly suggesting sexual favors in return for hiring, compensation, promotion, retention, decision, relocation, or allocation of job responsibility or work. Now we come to the She Box. So basically, the She Box is an initiative by the Government of India, and it has been enacted under the garb of this POSH Act 2013 with the objective to create a safe and secure workplace for women free from sexual harassment. The Act caters to women working both in organized and unorganized sectors and establishes a redressal mechanism for the disposal of their complaints. The Sexual Harassment Electronic Box, which is called the She Box, is an effort of the Government of India to provide a single window access to every woman irrespective of her work status, whether working in organized or unorganized, private or public sector, to facilitate the registration of complaints related to sexual harassment. Any woman facing sexual harassment at workplace can register their complaint through this portal. Once a complaint is submitted to the she box, it will be directly sent to the concerned authority having jurisdiction to take action into the matter. For registering complaints related to sexual harassment at workplace, through the she box, a valid email address is required. The registration of complaints through she box is very easy. To register the complaint, please click on the tab register your complaint as shown on the screen. Like if when you go to the particular website of she box, you will be able to see a register your complaint on the screen. You can go there, you can add your email address, and you can register your complaint much quicker. So this is a quick way of submitting and reporting any act of sexual harassment. So now I would like to conclude by saying that the POSH Act has been made to address the grievances of sexual harassment at workplace for women. And no employee in general also, should ever be put to a state of discomfort due to any unwelcoming acts of someone or any unwelcome behavior or any kind of acts which make you uncomfortable, causes a disharmony at workplace. So I think no employee shall ever be put to that state, and for that redressal we have the POSH Act. And it's not only the duty of an employee to report the particular act, it's also the duty of organizations to make their policies, the employee handbooks so stringent that all the employees are aware of this whole concept of sexual harassment at workplace, and be it any employee, before conducting such an act should be aware that this is not supposed to be done, and even an employee who's going through it should know that this is required to be reported. So thank you so much for joining today, and now the floor is open for questions. I would like to call our managing partner, Mr. Together, we'll take all the questions which you may have. Thank you.
The floor is open for questions.
Yeah, hi, this is Richa. I'm an in-house counsel, and I heard of the seminar from a newsletter that my colleague gets. So, yeah, thanks for this. Thanks, Tanya. This is very informative. There was a reference of service rules. I want to understand more about what service rules are, and how are they formed, and what's the applicability in general.
See, you will find the detailed service rules definitely. You will there are detailed service rules, but along with the POSH Act, the POSH rules had also come into picture, which are more detailed, and also they contain this act contains like a whole way of how you when are you supposed to file the complaint, how do you file the complaint. But the rules are more detailed with respect to filing the complaint, the authority, the way the trials are conducted, the way the whole inquiry is conducted. So that is like a detailed, but yes, along with the POSH Act 2013, those rules are also there, together they are both supposed to come as we follow.
Yeah. So hi. So just to add to what Tanya has said, the POSH Act is a pretty comprehensive act, and every company is under an obligation to have its own POSH policy. And typically, the act would provide for how a committee has to be enacted and how many members and what is the procedure for filing a complaint. But the onus about having a committee in place, informing the employees that we have a committee, who are the members of a committee, and how a complaint can be made by every employee, that onus falls on the company.
Right. Okay. And this is a very helpful PPT. So can the participants be shared this PPT after the seminar?
We will be uploading it on the our website, and you can absolutely. So I think by next 2 or 3 days it will be on our Lexfavios website.
Yes.
You can have it. Yeah, all participants will have it.
Yeah.
Great. Thank you.
Thank you.
Nothing from my side. Thanks.
Thank you.
Do we have any more questions?
questions?
Yeah, hi Tanya. First of all, thank you very much for the very informative session on the POSH. I have one question, like why the act only applies to the women? Why not for the men?
Yes, that I basically your question is very valid, and I agree of what you're saying. The act, whereas the act applies to women, but nobody stops organizations from creating gender neutral laws. Nobody, gender neutral guidelines, policies. Organizations can take that initiative, even though the law definitely is about women. But organizations can definitely take their initiative to draft their policies in a way which is completely gender neutral, and so that it can cater to both men and women.
So essentially, just to add to what Tanya is saying, typically as Tanya rightly said, and she started her presentation by saying the ethos or the beginning of harassment laws was based on Vishaka judgment, which was a woman being harassed, and that's how the law evolved. So typically, when we go to the POSH law, in essence, it says a woman being how a woman can complain, but rightly said, nothing stops a company or especially any organization, to have a gender neutral policy or have a policy where they include that if a complaint has to be made by a man, or any person. So that demarcation is, of course, we live in with the law, but then the law, once a company makes its own policies, the company has completely free hand and nothing stops a company from entertaining all sorts of complaints coming from anyone. So that is something, again, we said, the POSH acts, typically only gives you very broad guidelines, because the onus is entirely upon the company how to implement.
And adding to what Mr. Sumesh has said, I think that even though the law is definitely talks about women, but organizations, since it also poses a responsibility on employers to create a harmonious working environment, I think organizations can take steps, can take that initiative to make their policies gender neutral so that their working environment is harmonious, and both women and male employees have that kind of a redressal mechanism that they can freely approach the ICC for any kind of acts that are happening with them.
Thank you. Thank you very much.
Thank
And
you.
another question is that
I
when we form the policy, right, when we make our ICC members, like for the POSH, right, so is it mandatory to have an internal counselor also as a sixth person, or only five are mandatory?
No,
only five are
only
mandatory.
five are mandatory. No sixth person is compulsory to be appointed.
See,
That's
you have among the five. See, the only regulation is you should have one independent member.
Yes.
And again, so obviously the rest of the people are from the company only.
Yes, exactly.
Okay, thank you.
hi, Richa again. I have a related question with what Karamjeet had asked. So, okay, I do agree that nothing stops the company from having a gender neutral policy. But for example, if there's a company who has less than 10 employees and therefore it's not required to have an ICC and therefore constitutes a local committee with the help of the government. Now, in that scenario, if there's a local committee and if a man wants to raise a complaint, then he cannot, right? Because the local committee may not entertain it, saying that the aggrieved person is not a woman, therefore I will not take it up.
Just adding to it, it is again, nothing stops a company from having 4 or 5 employees also to have a ICC, because see what the law has said, you need to.
10 employees.
So minimum 10 employees is more for the convenience, like it is compulsory for companies over 10 or more employees to have a committee. But the law doesn't say that a company which has less than 10 employees
cannot form an ICC.
Cannot form a ICC or does not have a committee.
Yes.
The law is typically saying, they don't want to, it's a very reasonable law, they don't want to burden companies with 4 employees or 3 employees to have an ICC committee. But to answer the question, yes, if it goes to the general committee, which is formed by the government, they will not look into gender neutral complaints.
Yes.
But then the company, again, a company having less than 10 employees
Can also form an ICC.
Absolutely, So that's an optional thing. It's not compulsory.
Absolutely.
But nothing stops you from having one.
Okay. And one last question. Are there any major annual compliances under the POSH Act and rules?
So see, the compliance is basically annual filing. You have to do an annual filing under the POSH Act, So first and foremost, I think where we see from our experience is one, most of a lot of companies are still not having committees in place. So once you and also under the POSH Act, the government has made it compulsory to do an annual filing wherein you need to report the details of the members and if any complaints have been heard. So that becomes a till now very fair, like there's not been too much penal provisions or actions, but yeah, it's a mandatory compliance for every company over 10 employees to have a committee and then do one annual filing. So we as a law firm, again, we do a lot of hand-holding for POSH policies, assisting companies in drafting their policies. In fact, my colleague Tanya, who made the presentation, sits on the harassment committee of a few companies, and then obviously these annual filings and compliances. So that's what, as a law firm, we can assist and we assist most of our corporates.
Thank you. Thanks a lot.
Hi, this is Leena. My understanding is that the minimum requirement is 4 members. Is my understanding wrong? You just mentioned 5 members. My understanding is 4 members with 1 external member.
So that becomes.
That is, yeah.
That's 4 members, not 5 then, right?
External, right?
5 including external.
Including the external.
No, my understanding of the provision is 4 including the external member, because it says 1 has to be the presiding member, which essentially has to be a senior female employee, then not less than 2 members from among us employees, and then 1 external member. So that makes it 4 minimum requirement for the ICC constitution.
Yeah, that's my understanding too.
Just rechecking, because you mentioned, I thought my understanding is wrong.
Please also recheck, I think, because then we'll come back to it.
All right. So the another issue that I just wanted a clarification was, what if a complaint is made?
Please, I think I'll go over the provision again for you once again. So it basically one presiding officer who shall
Right.
Then comes not less than 2 members from amongst employees preferably committed to the cause of women, 1 member from amongst NGOs or associated commitment to the cause of women, and
So that takes it to 4, right?
Yes.
Yeah, 4.
Absolutely. Compulsory.
Okay. Okay, thanks. So the other clarification that the confusion that I have in my mind is, what happens if a complaint is made by a female employee against a male who is a visitor in the organization? Would the ICC have jurisdiction to investigate and adjudicate such a complaint, because the incident is happening in the organization, in the workplace, but the person who is responsible for the said incident is not an employee of the organization?
No, so
that is fine.
Yeah, strictly speaking, no,
Yeah.
because under the POSH Act, it's only against a disciplinary committee, or the committee can only take action against the employees, because technically then the reports will be filing of a police complaint.
Police complaint and IPC. Then.
Yeah, because see, what happens is, even if on a practical side, even if the committee was to take a cognizance of a complaint and hear the complaint, they have no power over the external.
Implemented, correct.
Because even if, let's say, the POSH, your committee says yes, the guy, there was a harassment. So, but
can't do anything.
You can't do anything. So typically, that's the reason. So then again, in case of an external person, then of course, like obviously, then the provision of IPC comes into place. Right?
Then it becomes an external issue.
See, basically, the ethos of the law is that first, in case there is a harassment qua the employee, between the employees, so the female person, or any aggrieved person should not have the inconvenience of directly reporting to the police station, going to a police station and filing a police complaint. To prevent that step, we take one more step has been added, that between organizations, if there is any harassment, that has to be heard by the complaints committee. And obviously anything external, there are already enough provisions under IPC laws and laws to prevent any harassment or any such actions.
But the complainant can be somebody who is not an employee, right?
No, complainant has to be employed.
Has to be an employee.
As I said, number 1, for a complainant has to be employed.
Yes.
The person against you are complaining should also be ideally an employee.
Yes.
But on a hypothetical situation, if the committee were to take over a complaint from an employee against an external person, that even if the committee takes a complaint or passes an order, that has no persuasive, that has no real practical value in any sense, what we are telling you. But yeah, non-employee cannot make a complaint.
Under this POSH
Yeah.
Act.
But as Tanya had displayed in the PPT that she was displaying here, the definition of the aggrieved woman doesn't say that the woman has to be an employee. It says whether employed or not.
Yeah, but again, see, again, like, you know, as I said, you know, the aggrieved is, but a non-employee, again, like, you know, so it's like, you know, what position the person is, like, you know, can, so it's like saying, you know, yeah, if a external person is coming and, like,
If a female visits office and is subjected to sexual harassment,
by an
will she
employee,
not get covered under the definition of aggrieved woman? I think she should get covered.
She can.
Then
Then
she
she
can.
can.
Yeah,
Yes,
if it's-
then she can.
if the harassment complaint is against the employee, then it can. Yes.
Yes, thank you. That clarifies. Thanks.
No, I have a doubt here. So I think whether employed or not, the understanding is to include consultants or trainees or apprentices. But for example, if there's a client at my office, and if one of my employees commits an activity which amounts to sexual harassment against the client, then the client can file an against to my ICC. I don't think so.
See, if a female employee comes to the office and there is a harassment
No,
by
employee. I'm not talking about employee. Female employee नहीं बोल रही. Employee तो obviously covered है.
I'm saying
I'm
the
talking about
client, the client is harassed. So let's say a female client is harassed by a male employee of the organization. Then they would, you know, they would have
then I think the client should go to her ICC and not my ICC.
no, there
So
I
what?
no, so there you are wrong. Please appreciate the fact
Yes.
your, you know, only the ICC of the company where the complaint, the person
And
who
this
is
happens.
accused
Yes.
or has power. Let's say a client goes to his ICC, how can they take action against the B company,
Exactly.
the employee of another organization? So it's not vice versa. So basically, our ICC committee only has power over its own employees. It doesn't have power
Right.
over external people.
Yes.
So then
I
the
think that is
complaint.
why the definition has been put that way, that the aggrieved women includes non-employee also, but the person against whom the investigation is going to be carried out has to be essentially an employee.
See, that is the implied
That's
provision,
the-
because
yes.
how can, as I said, you know, on a hypothetical situation, in any given event, if a committee was to make a, let's say, any judgment, say yes, against a person who's a non-employee, how do you have any value? Then you are basically going back to the provision of the IPC and filing a police complaint, which you would have done in the, which will do in the first place. So it logically and practically it doesn't make, like, you know, the law is silent on it, but how can any ICC committee take up it? As I said, there is nothing stopping. The guidelines are only framework. Now you form a committee and say, I'll hear complaint against everyone. You can have that in your ICC complaint committee. No one stopping you from having. A company is free to formulate its own policy. But on a practical basis, does a policy which you make and or a you know, order you pass against an ex-employee or a non-employee, it has no value in real sense.
One more thing. If a complaint is filed against an employee and during the pendency of that complaint, the employee resigns, then what happens?
So still the committee
Complaint is still, yeah.
Complaint can still go on.
Yes, so
or
inquiry procedure needs to get
So
over.
should the resignation of such an employee be accepted by the employer pending investigation?
why not? You come. I think there is nothing stopping from. So generally, in such cases, we've seen, you know, the committee just passed. In fact, one of the reasons for resigning is because of a complaint.
Yes.
In my practical view, we've seen
Yes.
many cases where an employee is subjected to a, you know, is called for a committee while the committee is undertaking a process. So two things here. One, employee, you can't stop an employee from resigning, and number two, on a as per law, the committee can't leave this investigation
In
midway.
between, just because one of the parties has resigned.
Correct. I do agree with you on both the counts, but what happens if ultimately the committee comes to the conclusion and holds that person guilty, but that person's resignation already stands accepted, so it just becomes a paper order.
See, generally what happens is on a practical basis, usually where the person who is guilty has resigned, the committee would typically wrap up the investigation, and because generally the employees are asked to leave in most of the cases. I think we, at least in my experience, I've seldom seen things going very far, or unless there's something very serious. In most of the cases, the employee is asked to leave the organization, and while the resignation is accepted, the committee usually wraps up the order. I'm telling you what happens on a practical side of things, where we generally, when we accept the resignation, we also have another meeting and wrap up the investigation proceedings and pass order.
Okay.
That's more. So as I obviously there is of course one is the law which
Can't there be a would it be appropriate on behalf of the employer to make the release order subject to the outcome of the pending investigation before the ICC?
How does it so first, if an employee has resigned, can you stop under law, can you stop a person from leaving an organization? You can't.
No, one cannot stop a person from leaving the organization, but the provisions also provides for providing a monetary compensation to the complainant for the harassment.
As I said, there are two things here. The company may withhold his remuneration, may withhold his salary. As I said, number one, you can't stop him from leaving. Number two, yes, rightly said, the company has a right to withhold his, some remuneration or his salary benefits while the investigation is over. In fact, there have been cases where employees' stock options have been clawed back because he was found guilty of harassment. So we've seen that cases. So that is a completely discretionary power of the committee. So to answer your question, yes, you can't stop an employee from resigning, but yes, a monetary compensation is completely a discretionary power, and a company cases where.
And once that employee is relieved from the services, that employee is not going to be there and come before the ICC.
No, they can't, because see what on a practical work where we've seen in many cases where the compensation is withheld. As I said, in one of the cases, even the stock options were in one of the IT companies, the stock options were clawed back. So that again on a case-to-case basis. See, it's a powers of a committee, because committees generally have, that's the reason the law says have external members, have senior members, people who have some experience in dealing with harassment cases. You don't have people like who never dealt with these cases. So that is on a case-to-case basis. But yes, it's a discretion of a company to withhold his remuneration and let him go and say, okay, fine, we'll pay you pending the investigation. And generally, the investigation on a practical side are fast track in this case. Then he won't say that let the employee go. We'll continue the investigation very slow. That doesn't happen. I'm saying what happens more on the practical side of things.
Okay, thank you.
Yeah. Do you have any questions, or we can end the presentation? Okay, thanks everyone.
Thank you so much, everyone.
It was a great interaction with all of you, and we at Lexfavios are a full service law firm, and typically we are a corporate M&A, and the firm does a lot of work on the employment laws. As we said, Tanya sits on law of committees or the harassment committees, and in case any of the panelists or any of the participants you have any concerns on employment laws, feel free to reach out to us, and we will be uploading the presentation very shortly on our website.
Thank you so much.
Thanks everyone.